If you became a U.S. citizen through naturalization, and lately you found yourself lying awake at night wondering, can they take this away from me? You're not alone. You see the headlines. You see the enforcement footage. You hear the words crackdown, deportation, immigration overhaul, and suddenly something that once felt permanent starts to feel fragile. You worked for this. You studied for the civics test. You passed the interview. You stood in a courtroom and took the oath. You believed that moment meant safety, finality, protection. So when immigration policy dominates the news in February 2026, it's natural to ask, has anything changed about my citizenship? Is naturalized citizenship really secure? Could enforcement policies somehow reach me? Today, we're going to separate fear from fact, headlines from law, and speculation from constitutional reality, because there's a massive difference between a louder enforcement environment and an actual legal threat to your citizenship, and understanding that difference changes everything. You see the headlines, you see the enforcement footage, you hear the words crackdown, deportation, immigration overhaul, and suddenly something that once felt permanent starts to feel fragile. You worked for this. You studied for the civics test. You passed the interview. You stood in a courtroom and took the oath. You believed that moment meant safety, finality, protection. So when immigration policy dominates the news in February 2026, it's natural to ask, has anything changed about my citizenship? Is naturalized citizenship really secure? Could enforcement policies somehow reach me? Today, we're going to separate fear from fact, headlines from law, and speculation from constitutional reality. Because there's a massive difference between a louder enforcement environment and an actual legal threat to your citizenship, and understanding that difference changes everything. Hi, I'm Sophia, and welcome to USA Move Guide. My work is focused on breaking down immigration policy clearly, calmly, and factually, especially during moments like this when anxiety spreads faster than accurate information. In this video, we're going to walk step by step through what Trump immigration policy in February 2026 actually means for naturalized citizens, what the Constitution guarantees, what denaturalization really is and what it is not, and the practical steps you should or shouldn't take right now. This is not about politics. It's about law, rights, and clarity. By the end of this, you'll know exactly where you stand, what is protected, and what you can confidently stop worrying about. And that clarity matters more than ever. Let's start with the foundation, because once you understand this clearly, a lot of the fear begins to fall away. Under the United States Constitution, citizenship once lawfully granted is permanent. That's not a political talking point. That's not dependent on who is president. That is constitutional law backed by Supreme Court precedent going back decades. If you completed the naturalization process, met the residency requirements, passed your civics and English exams, disclosed the required information, and took the oath of allegiance, you are a United States citizen with the same constitutional protections as someone born in this country. Your citizenship is not a visa. It is not a green card. It is not conditional status. It does not renew. It does not expire. And it cannot be taken away simply because immigration enforcement becomes more aggressive or political leadership changes priorities. Executive orders cannot override constitutional protections. Shifts in enforcement strategy cannot rewrite the 14th Amendment. Congress cannot pass a simple law that suddenly strips lawfully naturalized citizens of their status. Citizenship, once properly granted, is not fragile. It is one of the strongest legal statuses that exists in American law. Now, I want to pause here for a moment because this is important. Many people subconsciously carry over the anxiety they felt as permanent residents into their life as citizens. As a green card holder, your status could be questioned under certain circumstances. There were conditions. There were risks. There were renewal requirements and travel limitations. Citizenship is different. It is final. It is a constitutional status, not an administrative one. And if this kind of clear, fact-based breakdown is helpful to you, make sure you're subscribed to this channel so you don't have to rely on rumors or social media threads the next time immigration dominates the headlines. Accurate information is one of the most powerful forms of protection you have. But, and this is where we need to be precise, There is one narrow legal exception that people often hear about without fully understanding it. It's called denaturalization. And this word alone causes panic because it sounds like the government can simply undo citizenship. That's not what it means. Denaturalization is a formal legal process that can only happen in federal court and only under very specific circumstances. The government must prove that a person obtained citizenship through fraud or by willfully concealing a material fact during the naturalization process. This is not about policy disagreements. It's not about changing political parties. It's not about criticizing the government. It is about whether the original naturalization was legally valid. To meet that standard, prosecutors would have to show evidence that someone deliberately lied on their N-400 application, hid serious criminal history that would have made them ineligible, used a false identity, concealed involvement in persecution or terrorism, or omitted information that was legally material to the approval decision. And even then, it is not automatic. The government must file a civil lawsuit. The individual has the right to legal representation. There is discovery. There are evidentiary standards. There is a judge. The burden of proof is high. And historically, denaturalization cases are rare, time-consuming, and expensive. They are not mass administrative actions. They are individualized court proceedings that often take years to resolve. This distinction matters enormously in 2026 because when people hear about stronger immigration enforcement, some assume that citizenship could somehow be swept into that enforcement wave. But denaturalization is not a policy tool that can be expanded casually. The legal standard has not changed. There has been no new lawing the burden of proof. There has been no Supreme Court ruling weakening constitutional protections for naturalized citizens. Even if an administration wanted to pursue denaturalization cases more aggressively in cases of proven fraud, it would still be bound by the same constitutional requirements and due process protections that have existed for decades. So when you hear the phrase revoking citizenship, understand that in reality it refers to a narrow, court-driven process tied to fraud, not a political lever that can be pulled against law-abiding naturalized Americans. So, if naturalized citizenship is constitutionally protected and denaturalization is rare and fraud-based, what exactly is happening right now in February 2026 that's making so many people uneasy? The answer is enforcement visibility. The current administration has significantly increased immigration enforcement operations. ICE activity is more frequent and more public. Detention policies are stricter. Border enforcement has intensified. Deportation efforts are being prioritized for individuals who are undocumented or who have final removal orders. That shift in visibility changes how communities feel, even if it doesn't change the legal reality for citizens. When you see workplace raids covered on the news, when you hear about large-scale removal operations, when social media amplifies every enforcement story, it creates the impression that the entire immigration landscape is unstable. But here's the critical distinction. Enforcement actions target immigration status violations. Naturalized citizens do not have an immigration status. You have citizenship. You are not in the category of people subject to deportation proceedings. You do not need a visa. You do not need to renew anything. Your legal relationship with the United States is fundamentally different from someone who is undocumented, or even someone who is a permanent resident. This is where confusion spreads. Immigration policy debates often get framed broadly. Crackdown on immigrants, strict immigration overhaul, new deportation push, but those phrases collapse multiple legal categories into one emotional headline. A green card holder is not the same as an undocumented immigrant. A visa holder is not the same as a naturalized citizen. Enforcement aimed at unlawful presence does not legally extend to people who have completed naturalization. Yet, when rhetoric becomes intense, people who spent years navigating a vulnerable immigration system can instinctively feel like that vulnerability has returned. It hasn't. The tone may be harsher. The enforcement may be more visible. But tone is not law. Visibility is not a constitutional amendment. And intensity does not rewrite citizenship protections. Now let's address three of the most common claims circulating right now, because misinformation thrives in environments like this. The first claim is that mass denaturalization is coming, that the government is preparing to strip citizenship from large numbers of naturalized Americans. There is no legal mechanism for this. There is no new legislation authorizing it. There has been no constitutional change allowing it. Denaturalization, as we discussed, requires individualized federal court proceedings tied to fraud. It cannot be executed in bulk through administrative action. The second claim is that certain nationalities or religious groups are being targeted for citizenship revocation. While immigration enforcement priorities can focus on particular geographic regions or security concerns, denaturalization cases must be based on fraud or material misrepresentation, not race, religion, ethnicity, or political belief. Targeting citizenship revocation based on those characteristics would be unconstitutional and immediately challenged in federal court. The third claim is that naturalized citizens need to take urgent dramatic steps to protect their citizenship. Renouncing prior citizenship immediately, filing special paperwork, paying for protection services, or registering with organizations promising safeguards. None of that is necessary. Your citizenship is protected by the Constitution, not by additional filings or private services. Fear-based businesses often emerge during times of uncertainty. Be cautious of anyone asking you to pay money to secure something that is already legally secure. Understanding what is actually happening and what is not changes how you respond. There is a real enforcement shift in 2026. There is a heightened focus on undocumented status. There is political intensity around immigration, but none of those developments alter the constitutional permanence of lawfully obtained naturalized citizenship. When you separate enforcement optics from legal authority, the picture becomes much clearer and much less frightening. Now that we've separated legal reality from political noise, let's shift into something practical. Not because your citizenship is in danger, but because clarity becomes even more powerful when you know what to do next. The first step is simple. Safeguard your documentation. Keep your naturalization certificate in a secure location. Make physical copies and, if possible, secure digital scans stored safely. This is not because someone is coming to question your citizenship at random. It's because having immediate access to proof eliminates stress if you ever need to apply for a passport, replace documents, sponsor a family member, or verify your status for any reason. Organization reduces anxiety. The second step is understanding your rights as a citizen. You have full constitutional protections. You have the right to due process. You cannot be deported. You can travel on a U.S. passport. You can vote. You can petition for family members. These rights are not symbolic. They are enforceable. Sometimes simply reviewing what citizenship legally grants you restores a sense of stability that headlines can temporarily shake. Third, if you have family members who are lawful permanent residents and eligible for naturalization, this is an important moment to consider encouraging them to apply. Permanent residence is strong, but it is not the same as citizenship. Green card holders can still be placed into removal proceedings under certain circumstances. They must maintain residency requirements. They are subject to immigration enforcement rules in ways citizens are not. Naturalization provides finality. The process itself has not fundamentally changed in 2026. It still requires physical presence, continuous residence, English proficiency, civics knowledge, and good moral character. But if someone in your family qualifies, pursuing citizenship can provide long-term security that is particularly meaningful in an enforcement-heavy climate. If this breakdown is helping you think more clearly about your situation or your family's options, consider sharing this video with someone who might be quietly worried but hasn't asked these questions out loud. Sometimes clarity spreads one conversation at a time. Now let's talk about more complicated family scenarios, because this is often where anxiety really lives. If you have undocumented relatives, the current environment is not favorable for ignoring that reality. Enforcement is active. Deportations are occurring. Undocumented status carries real vulnerability. And hoping that visibility will fade is not a strategy. That doesn't mean panic. It means consultation. There may be pathways someone hasn't explored. Adjustment through family, humanitarian protections, waivers, cancellation of removal, or other relief depending on the facts. But those options are case-specific and require a licensed immigration attorney to evaluate properly. Guesswork and internet advice are dangerous in this climate. If you are sponsoring a relative abroad, Understand that family-based immigration remains legal, but processing times may lengthen, scrutiny may increase, and policy adjustments could affect categories or numerical caps. Delaying unnecessarily can sometimes mean facing stricter standards later. And if you travel internationally as a naturalized citizen, always travel on your U.S. passport. The United States recognizes dual citizenship, but some countries do not. If you return to your country of origin, be aware of that country's laws regarding dual nationality, taxation, or military obligations. None of those issues affect your U.S. citizenship, but they are practical realities worth understanding before you travel. What all of this comes down to is this: your citizenship itself is stable, but your family's immigration situations may still require attention. Stability at the top of the ladder does not automatically secure every rung beneath it. Being proactive, not fearful, but proactive is the most constructive response to a high enforcement environment. At this point, you might be asking a very practical question. Do I need an immigration attorney right now? And for most naturalized citizens with straightforward histories, the answer is no. If you obtained your citizenship lawfully, disclosed required information honestly, and have not been contacted by the government regarding fraud or misrepresentation, there is no preventive legal filing you need to make. There is no special protective step required. Citizenship does not need maintenance. It does not need renewal. It does not require defensive paperwork. However, there are specific situations where consulting an immigration attorney makes sense. If you are sponsoring a family member, and the case involves prior overstays, removal orders, criminal history, or complex waivers, you absolutely want professional guidance. If you have undocumented relatives trying to assess their options, that evaluation must be individualized. If you ever receive formal communication from USCIS, the Department of Justice, or any federal agency questioning past immigration representations, that is the moment to seek counsel immediately. And when I say attorney, I mean a licensed immigration lawyer, someone admitted to practice law, ideally focused specifically on immigration matters, and preferably connected to reputable organizations such as the American Immigration Lawyers Association. Be cautious of anyone who guarantees outcomes. Be cautious of large cash demands without written agreements. Be cautious of notarios or consultants presenting themselves as attorneys when they are not licensed to practice law. Immigration fraud increases in periods of uncertainty because fear creates opportunity. A real attorney will evaluate your facts, explain risks clearly, and never promise impossible results. They will not tell you they can protect already secure citizenship for a fee. They will not invent emergency filings that do not exist. Legal guidance should reduce anxiety, not exploit it. Now, I want to shift to something that doesn't show up in statutes or court rulings but is very real: emotional residue. Many naturalized citizens carry years, sometimes decades, of immigration-related stress. You may remember what it felt like to wait for visa approvals, to check case statuses online obsessively, to worry about missing a document, to fear that a mistake could derail everything. That psychological imprint doesn't disappear overnight just because you received a certificate of naturalization. So, when enforcement headlines surge, even if your logical brain understands that your citizenship is secure, your nervous system may react differently. You might feel a flash of the old vulnerability. You might question something that is legally settled. That reaction doesn't mean you misunderstand the law. It means you lived through uncertainty for a long time. It's important to give yourself credit for that journey. You navigated a complex legal system. You met the requirements. You earned citizenship lawfully. The anxiety you once felt was rational in earlier stages of your immigration process, but the legal landscape of your status has changed. You are no longer in a provisional category. If you find that the current political climate reactivates old fears despite knowing the legal facts, consider leaning into community. Talk to other naturalized citizens who share similar experiences. Connect with immigrant advocacy organizations that provide accurate updates. If stress feels overwhelming, there is no weakness in seeking counseling support to process it. Security is not only a legal condition, and it's also a psychological one, and both matter. As we look at the bigger picture in February 2026, it's important to separate two forces that often get blended together: political climate and constitutional structure. Political climate can shift quickly. Enforcement priorities can intensify. public rhetoric can become sharper. Media coverage can amplify every action. But constitutional structure moves slowly, deliberately, and with high barriers to change. Citizenship falls into that structural category. It is anchored in the 14th Amendment and reinforced by decades of Supreme Court precedent. That foundation does not move with each election cycle. So when you hear sweeping language about immigration crackdowns, remember that those policies operate within legal categories: undocumented status, visa violations, removal orders, asylum eligibility. Citizenship is a different category entirely. If you naturalize lawfully and honestly, there is no hidden mechanism waiting to undo that. There is no executive shortcut. There is no quiet administrative sweep. There is no new 2026 statute that has rewritten the rules of denaturalization. The legal standard remains fraud or willful concealment of material fact proven in federal court with full due process protections. Here's what we know clearly. Immigration enforcement in 2026 is visible and active. Deportations of undocumented individuals are occurring. Border and detention policies have tightened. Policy debates around asylum, work visas, and family-based immigration continue. But none of those developments alter the permanence of lawfully obtained naturalized citizenship. If you answered your application truthfully, disclosed what you were required to disclose, met eligibility requirements, and took the oath, your citizenship is secure under the Constitution. That is not optimism. It is legal fact. So the path forward is not panic. It is awareness. Stay informed through reliable sources like USCIS, the State Department, reputable legal organizations, and licensed immigration attorneys. Keep your documents organized. Encourage eligible family members to naturalize. Seek professional advice when cases are complex. And most importantly, allow yourself to live in the stability you earned. You have the right to vote. You have the right to hold a U.S. passport. You have the right to petition for family members. You have the right to live here without fear of deportation. Those rights are not symbolic. They are enforceable constitutional protections, and understanding them fully is one of the strongest responses to a noisy political environment. If this video has helped you feel clearer about what naturalized citizenship actually protects and what it does not, make sure you subscribe to USA Move Guide. We're committed to fact-based immigration guidance that cuts through misinformation and focuses on what the law actually says. Share this video with someone who might be worried but hasn't had access to accurate information. And if there's a specific claim you've heard or a topic you want us to address next, leave it in the comments. Your questions help shape future videos that serve real concerns in our community. Thank you for being here, and thank you for being part of a space where accurate information is treated as protection, not politics.